Hello. Well, I'm really delighted to be here today to talk to you about what I think is a really quite controversial concept, the concept of positive action or affirmative action, or whatever you might want to term it. And over the next 15 minutes, what I'm going to challenge you to do is to think about whether or not positive or affirmative action is a justifiable tool to address the embedded inequalities that exist within our society, and in particular, within our workplaces. So I'm going to start with a quote from the formidable Maya Angelou. And in 2008, she said this. She said, "You can be kind and true and fair and generous and just, but to be that thing time after time, you have to have courage." And I think positive action is a tool that requires courage. Addressing embedded inequalities requires courage. So what I'm asking you to do really today is to think about whether in a challenging world of embedded inequalities, we need to address those inequalities through courageous measures, and whether positive action is one of those courageous measures. So, very, very briefly, what are the issues? What are these embedded inequalities we're talking about? Well, I could stand here and I could quote statistics, I could quote data, but I'm just going to give you the headlines. The headlines are, we still have, particularly in the workplace, we have embedded inequalities around the recruitment and representation of marginalized groups. We have issues around the progression and retention of marginalized groups. And perhaps even more importantly, we have issues around the unequal experiences that marginalized groups face within society as a whole, but in particular within the workplace. So what tools do we have available? Well, I'm going to suggest to you we have three different categories of tools. The first tool we have available is what I might term anti-discrimination measures. And these are the things that the law requires us to do to prevent discrimination. The second tool, and we hear a lot about this term, is to put in place inclusive practices. And really what we're doing there is we're putting measures in place which apply to everybody, but which ensure that particular groups aren't disadvantaged. Now, most employers, most organizations feel comfortable with those two measures. However, the third measure, and this is what I really want to focus down, is positive action. And this is a far more controversial tool to address those embedded inequalities that exist. So the first question has to be, what is positive action? Now, many of you will have seen this graphic previously. This is a slightly updated version, which has been updated by the artist Angus Maguire. And what this graphic, I think, really shows very well indeed is what we mean by positive action and why it might be necessary. So, on the left of the slide, what we see is the form of equality. And we see individuals all being treated in the same way, but not recognizing difference. We are treating likes alike. We are treating human beings alike. And for some people, that is what equality means. It's a formal type of equality. However, if we look at the other half of the slide, we look at equity. And here what we see is a recognition of difference. We see that we are not all the same. We have certain elements of our identity that might disadvantage us within society. And in those circumstances, what we might have to do is we might have to provide additional special measures to provide equality of opportunity, to enable us to see the sports field in this example. Now, many of you may be thinking, well, there's a third possibility there. The third possibility is to take away the fence. And if you take away the fence, you're taking away the issue, you're taking away the barrier, and you're allowing everybody the same opportunity. Now, if that's possible, that's fantastic. That would be the way to achieve equality. However, my challenge to you is sometimes that isn't possible. It's not possible to remove the fence. Perhaps you don't understand what that barrier is. Perhaps you don't understand how you can remove that fence. And in those circumstances, we have to put in place special measures. We have to put in place positive action. So, a formal definition of positive action might be some form of preferential treatment, special treatment, targeted treatment, which is allocated to members of underrepresented, disadvantaged, underprivileged groups, which stems from embedded past or present discrimination. We've had positive action for decades. And back in 1986, Chris McCrudden suggested a typography of positive action, which ranged from special measures that would provide equality of opportunity for individuals, which would be things like outreach, encouraging people to apply for different jobs where they are disadvantaged or underrepresented, moving right the way through to a more controversial type of positive action, which might be termed equality of outcome, seeking to provide people with an outcome because they form part of a marginalized group. An absolute preference to give somebody a role, a job, a promotion, where they come from a group that's disadvantaged or underrepresented. So all of this in the UK is bound by what the law tells us we can do. One of the key issues with positive action is that when you put in place that special measure, which is seeking to address disadvantage, you are inevitably going to be treating the people who don't fall within a particular group less favorably. And in those circumstances, you may face what we call reverse discrimination. Now, the law doesn't require positive action to take place. It's permissive. It's not mandated. So basically, the only way that positive action really is used within our law is as a defense. So if somebody comes along and you put a piece of positive action in place and says, well, I don't fall within that group, but I'm going to take a claim against you because I've been discriminated against, you can use the fact you've carried out lawful positive action as a defense. So what does the law allow us to do? When can we use it as a defense? Well, the law says this. The law says that if, as an organization, as an employer, you reasonably think that there is disadvantage, there is underrepresentation, there is particular need of a marginalized group within your workplace, within your organization, then you can put in place a special measure to address that, which is targeted at that group. But only if you do so in a way that's proportionate. You cannot use a sledgehammer to crack a nut. A slightly more controversial permitted piece of positive action in our law is something called the tie break. So if you have two people who are as qualified as each other within the workplace, and you think that a particular group is underrepresented or disadvantaged, you can choose the person in a recruitment or promotion exercise from that disadvantaged or underrepresented group. Now that starts to feel a little bit more difficult, a little bit more like equality of outcome rather than equality of opportunity. And all of our law is underpinned by the EU framework. Even though we've gone through Brexit here in the UK, that EU framework still underpins all of our law in terms of positive action. It's been built into our law. The EU framework provides us with even more guidance on this. It says three things that we need to be aware of. Firstly, if you're going to put in place lawful positive action to be able to use it as a defense, you must have what's called a sunset provision in place. You can't just carry on a piece of positive action indefinitely without having a date at which you're going to monitor, review its effectiveness. If it doesn't work, get rid of it. If it's not working as well as it could do, tweak it. Yeah? That's important. Secondly, you have to have what's called a savings clause in place. Now, what a savings clause is, it's a discretionary element. So if somebody comes along and says, well, I'm not part of that marginalized group, but I face the same disadvantage, you have to have that discretion built in to address that person's disadvantage as well. And finally, you have to behave proportionately. So your positive action measure should only do what is absolutely necessary to address your issue, to address the disadvantage, to address the underrepresentation. Now, I've spent the last few years talking to organizations, talking to individuals, talking to sector bodies about what the problem is with positive action. Why is it controversial? Why did I introduce this talk saying this is controversial? And this is what they tell me. There is a lack of understanding and awareness. One of the reasons I do these talks, to promote awareness, to promote understanding. And that lack of awareness and understanding leads to fear of reverse discrimination claims. It leads to fear of legal liability. If you are only permitted to do something, you're not required to do something, and it's going to open you up to the risk of legal liability, why would you do it? Why would you put yourself at that risk? The other issue, people say it ignores the principle of merit, that all-important fundamental principle of merit within the workplace. By putting in place positive action, there's that fear that you're ignoring that. This is one of the ones that surprised me. The reluctance of potential beneficiaries. Those individuals who are potentially the people we want to benefit from the positive action often pull away from it, often feel that it's applied in a tokenistic way. Often it is applied in a tokenistic way and a standardized way by organizations. They simply take a piece of positive action that they've seen another organization put in place and assume it's going to solve their problems, and then shocked when it doesn't. So my challenge to you is to reimagine positive action. How can we make this a justifiable tool? How can we address all of those concerns that organizations have about using it? So my argument is that actually the law, if applied properly, can mean we have a very successful piece of positive action. It requires you to shine a light on your issue. You have to put in place an evidence-based approach. So you have to think about what your problem really is and then apply and develop a really innovative tool to address that problem. One size does not fit all. You can't take an off-the-peg piece of positive action and expect it to work for your particular issue within your organization. Sector bodies need to be encouraged to promote and guide and break down the mythology around positive action. Organizations need to work together to collaborate, to share information, not to copy, but to share information as to what works. For public sector organizations, there is something called the public sector equality duty. And actually, that public sector equality duty in many ways promotes public bodies such as universities and requires them to think about applying positive action in an effective way. And this is important. It is only one tool within our toolkit to address those embedded issues we talked about at the beginning. It has to be applied as part of a holistic life cycle approach. Putting in place a positive action measure and expecting it to succeed and address your underrepresentation, address any disadvantage a particular group faces, is unrealistic. So, for example, if you put in place a piece of positive action which increases representation of women within a male-dominated workplace, you can't expect that to work if you don't also ensure that that woman, when you brought her into the workplace, is going to be treated fairly, is not going to be subjected to harassment. So it has to work as part of that package. I think this is a really nice quote. This is one of my research participants who said, look, we've had positive action for decades, and it really hasn't worked. And we keep doing the same thing and expecting it to work. We need to do things differently. So what I'm suggesting to you is we need a framework in place. We need a framework that enables us to put in place robust, effective positive action, which is evidence-based, so we can see where the problems are, where the issues are, where the disadvantage is, and why it exists. Don't just rely on statistics. Put in place measures that are based on qualitative and quantitative evidence. Tailor it to your need and to your issue. Be proportionate. Use the measure that is absolutely necessary to address the issue that you have. Take targeted action, which is working smarter, not harder. It is always going to be a leap of faith, because I can't tell you, unless you have a claim and it goes to the courts, whether or not your positive action is going to be considered lawful. But very few cases actually go to the courts. We have only a handful of cases which have ever gone to the courts to determine whether or not positive action is effective. If you put a robust process in place, you're transparent, you're proportionate, it is going to be far more likely to be effective, and it's going to be far more likely to address your issue. So I'm going to end on another quote, this time from Aristotle, but I'm not going to read out the original Aristotle quote. What I'm going to do is paraphrase it. What we think he said here was that the worst form of inequality is to try to make unequal things equal. Positive action is the recognition of that. We are all different. We all have different elements of our identity, which means that we cannot treat everybody the same. Sometimes it's not possible to remove the fence. And where it's not possible to remove the fence, what we have to do is really consider whether or not we can put a very effective, very robust piece of positive action in place. So my challenge to you today is to think about whether or not, having heard what you've heard, this is a justifiable tool. If you're interested in any of the research, there's plenty of research out there, but I thank you very much for listening today.